Welcome back to the channel, everybody. It is Thirsty Thursday, and oh, were we thirsty, and oh, does Justice Thomas serve them tall. So if you haven't seen in the news yet already, we did get the opinion from the New York State Rifle and Pistol Association v. Bruen. We are currently analyzing it. Obviously, we need to go through it and see what it's worth and what we can do with it ultimately, but as we're doing that, we kind of got a little treat here. I wanted to get first impressions, so we do have from Michelle and Associates and Second Amendment Law Center, we have Tiffany Chevrant on here with us. Tiffany, thank you for taking the time.
Yeah, thanks for having me.
Awesome. Well, I just wanted to get kind of your first impressions reading this opinion. It's not even an hour old yet, but there's got to be first impressions, right? So what are you seeing when you're reading through this the first time?
Yeah, very exciting day for Second Amendment and gun owners, obviously. It's something we've been waiting for a very long time to see from the Supreme Court. And when they released it this morning, obviously analysis started immediately. Our team is working through it right now, but there are a couple of really great nuggets that have come out of this so far, even though we haven't done a deep dive yet and completed that. But a lot of good stuff. The main one, good cause, is in big trouble for California when it comes to issuing CCWs.
Awesome. So, reading through this, I think the document was 135 pages. I think you've got something like between 60 and 70 pages in the actual decision from Justice Thomas. You had some concurrent opinions, and then you also had the dissent opinion. I'm also kind of curious, what weight do all of those other opinions hold that aren't Justice Thomas's here?
Sure. Well, everybody likes to have their own concurring opinion on a big case like this, obviously. And you're going to see them quoted in the opposition, who are trying to pull out something for themselves and for their side of the argument. But concurring opinions are just that. They're concurring. The only opinion that matters is the majority opinion. And that's the one that we are looking to right now. The dissent does not matter, even though people will try to cite that in cases in the future, but that's not binding.
Got it. Well, one of the things that we were talking about, well, I had Chuck on several weeks ago. We were talking about the scrutiny. We were because that's how it ultimately affects us here in California, right, is how they view these cases. New York is all the way across the country. I know this is like a federal court that we're dealing with. So at first glance, again, because I know that there's a lot of analyzing that still has to go on, what are you seeing with the scrutiny on this case?
Sure. So it does not appear right now that we got strict scrutiny exactly as you would typically define it, but they did, it looks like, replace what courts have been using as a two-part test for the Second Amendment with a one-part test, basically. And that test is that the courts now must analyze whatever it is they're looking at under Second Amendment. They must analyze it by history and tradition of what was going on at the time the Second Amendment and the 14th Amendment were passed. And so that's a huge difference. It's pretty much devastating to the government when they talk about these types of cases, because it makes it much more difficult for them to prove that what they want to do is constitutional. And what you're probably going to see is a lot of junk history coming out. We've had junk science that comes out in certain matters, but this is going to be junk history. They're going to try to throw everything they can at this in every case. And every opinion from now on will probably be a history lesson for a lot of people. It was funny, I was on social media a little bit earlier and noticed that some of the opposing groups are already saying, oh, they got it wrong. They got it wrong. We'll let you know when we read the opinion. So they haven't even read the opinion. They don't even know what the justices have said in the majority opinion, but they're already saying that they got it wrong. And it's just not true. The justices made it very clear that the Second Amendment is no longer a second class right. It should be viewed just like any other foundational right.
Well, that is awesome. I know that there's still a lot of work to be done. Tiffany, I appreciate you coming on and giving us some of this insight. And for all of you at home, keep an eye out. CRPA here, we're going to be putting out some videos. We're going to be putting out some emails with analysis on this case and some potential action that we're going to have here in the future based on it. So we'll see you soon.